Are you able to see the screen? Yes, please confirm.
Yes, ma'am.
Okay. So we have started with the free consent, wherein we have already discussed the elements coercion, undue influence, and fraud. So today we are going to cover the element misrepresentation. Okay. So now when we have discussed about the fraud, we have discussed the essential elements that there should be a positive statement or assertion wherein the person is aware of about the falsehood of the statement. But when we talk about the misrepresentation, in misrepresentation, this is called unintentional. So when we talk about unintentional, unintentional means either you are making a statement of fact, you are hiding concealment of some fact is there, or there is breach of duty. In all these circumstances, there is no intention of the party to deceive the other party, right? So that it has been made, that's perfectly all right, that the wrong statement has been made, or any hiding or facts have not been disclosed, or any breach of duty was there. But the reason that the person himself was not aware of the fact of the falsehood of the statement, as well as the person himself have not bothered to check about the authenticity or the truth of a particular statement. But again, the intention is not to deceive the other party. But wherever the consent is affected by misrepresentation, so it says that the contract is voidable at the option of the party whose consent has been so affected. So if we talk about the definition, it says that section 18 says that the positive assertion in a manner not warranted by information of person making it of that which is not true, though he believes it to be true. So it means that when you are making a particular positive statement, in that particular statement you are not aware of the truth of that statement, right? So it is not warranted by the information, it's not backed up by the we can say the facts and figures, but you have made the statement that is true. But once this particular statement is true, this statement is, we can say, one second, let me see any queries here. Yes, Utkarsh, please go ahead.
मैम फिर डिफरेंस मिसरिप्रेजेंटेशन और फ्रॉड में यही है कि अगर यही चीज इंटेंशनली होती तो ये फ्रॉड हो जाता.
Yes, the major difference is of the intention.
तो
If it
मैम ये
will
मिस
have, hmm,
हाँ जी मैम.
yes
तो मैम
बेटा.
ये मिसरिप्रेजेंटेशन डिफेंस भी यूज डिफेंस की तरह भी तो यूज हो सकता है ना फिर.
See, there is when we'll discuss. So, in case of misrepresentation, when the particular statement is being used, so you have to show the other person has suffered the loss. तो आपने intentionally किया या non intentionally किया. अगर आपने intentionally किया तो उसमें हम damages claim कर सकते हैं. Unintentionally किया तो आपके पास contract को set aside करने की option और legal right same रहता है, but उसके अंदर the cause is covered as misrepresentation. That person has shared the information, but the particular information was not, warranted by the authenticity or the truth. So yeah,
ओके
this
मैम.
one we were discussing कि जब हम पॉजिटिव स्टेटमेंट देते हैं तो उस केस में वो द पर्सन हु इज मेकिंग द स्टेटमेंट ही बिलीव्स इट टू बी ट्रू, though it is not true. And if it was his duty to check that whether particular statement is true or not, तो उस situation के अंदर it was his duty to check. So next point आ जाएगा breach of duty. पहला आ गया आपने
ओके
positive
मैम.
statement दी, एक आ गया आपका concealment of facts, right? You have not disclosed all the facts and figures. And तीसरा आ गया breach of duty. So आपने it was your duty to check that whether the particular information which you are sharing with the customer or which you are sharing with the other party, whether it is true or not. but you have made the statement for the sale purpose and you have not fulfilled your duty. So then also it will be regarded as misrepresentation, right? So if you see the information, it says any breach of duty which without an intent to deceive, आपकी mal intention नहीं है, gains or an advantage to the person committing it. It means the person who is making a misrepresentation, he is getting the advantage of that particular statement, or anyone claiming under him, or any agent or any salesperson making the claim under him, by misleading another to his prejudice or to the prejudice of anyone claiming under him. It means कि जैसे situation हो, जैसे circumstances हो, जैसे option हो, उस option के basis पे, to the prejudice of your party, prejudice of the person who is making the statement, either he himself or any agent on his behalf, in that particular situation, the person is misleading the other and availing the advantageous position. So for example, if certain sale is to be made, and you can say that if you do not take the offer today, so this offer is till today 6 p.m. only, and you sometimes, you enter into certain deals, the person says that these are the benefit of this particular deal, but you have to close it during this webinar only, then only you will be able to get the access or this particular discount or a particular scheme, and in next 20 minutes you have to close. So there was a pressure, right? But there was no intention related to this, and even after 20 minutes gets over, you are receiving an email that you can receive the information or take the decision in next 24 hours. So in that case, the person is taking the advantage of the position as per the availability of the option in that case. So it generally happens, we must have come across these kind of situations. So there is a breach of duty. So once you have missed the option and you are very disappointed, and you were willing to join, but in those 20 minutes your net connectivity was disturbed, or somehow you could not connect the person, and when you later receive the mail, and that person, then you acknowledge the mail, and the person says no, it was only for 20 minutes, then you can fight for it, because this was the in the because you have received the mail, you have received the information, so it means that the offer is still valid. So misrepresentation can be in form of to encourage some person to enter into contract, to receive any kind of advantage, etc. Another situation is causing, however innocently, a party to an agreement to make mistake as to substance of the thing which is subject matter to the agreement. So it means you are not disclosing complete things, or you are silent in that particular situation. So in that case, what will happen? So in that case, if you remain silent, you remain you have not disclosed the complete facts, and but this particular situation has led the other party to understand or to misunderstand the facts of the situation. This will also considered as the misrepresentation. So there is no intention, because fraud में हम कहते हैं कि कोई भी एक्टिविटी जो किसी को डिफ्रॉड करने के लिए फिट होती है, वो फ्रॉड में कवर हो जाती है. We have discussed that there is the other person must have suffered the loss. There is a promise with an intention not to perform. These points we have discussed, that there is a fraud may the act has been done with an intention to defraud others, there should be loss by the party, and you have made a particular promise where you have never any intention to perform that particular promise. तो उसमें आप intentionally दूसरी पार्टी को मिसलेड कर रहे हो. Here you are doing it, but you are doing it unintentionally. So basic difference आपका intention का आ जाता है. So in this particular case, if you are making any hiding any fact or not disclosing anything or doing something wherein the other person is misled or guided, misunderstand the terms of the condition, and these facts are related to the subject matter of the contract where our decision will be affected. So in all these situations, it will lead to misrepresentation. For example, there is a statement that Mr. A is going to be the next CEO of the particular company. So you have no do not have any authentic information, but you have made this particular statement. On the basis of this, the other person have purchased the shares of the particular company, and later on that such and such person did not join, and the company was not doing well. So you can set aside the contract on the basis of that the purchase of the share was on the decision that the particular person is going to join as a director or as a CEO of the company. So that person is very good industrialist or very good name to the company. So by his name the company is going to grow. So there can be so many things. तो basically जो भी decision है और जो भी information है, it should be related to the subject matter of the contract. It should have affected your decision in entering into the contract, right? Then there is breach of duty. So whenever we are taking any kind of agreement, any policy, so nowadays the things are streamlined wherein we have to give all the documents, etc. But if you are providing wrong documents intentionally, it is going to be the fraud. Or if you are unintentionally or not sharing the complete age or any particular illness you have suffered earlier, so this will be considered as the breach of duty. So if it is being done intentionally, it would come under fraud. If it would have been done unintentionally, it would be known as breach of duty. So you have not got your medical done, but you have just got it checked, and even you were not aware of that this particular problem is going on in you, and but you have taken the policy. So this is a LIC. You can talk about the mediclaim or to avail other benefits as well. Then there can be the mistakes about the subject matter as well. So what we understand by the misrepresentation, that there is a false representation in terms of positive statement, in terms of hiding of the statement, or in terms of concealment of the facts, which led to other party to commit mistake about the subject matter of the contract. But again, the essential element is that there was no intention to deceive. It is only to enter into the contract and to receive advantage by entering into the contract. Then misrepresentation must be of material facts. If you are talking about any distant thing or any thing which is not directly related to the contract, then in that particular case this will not amount to misrepresentation. It should be directly related to the subject matter of contract and must affect the consent of the party. If it would have not been made, the other party would have not been entered into the contract. Then it should be made before the entering of the contract. If it is made afterwards, so as it does not affect the decision, it will not be covered under the misrepresentation, hence will not give you right to set aside the contract. It can be made by a party or agent, not a stranger. If any stranger is making a statement that Mr. So and so will become the director of the particular company, and then you are deciding, so it has not, the person who is making you enter into the contract has not affected your consent. Some third party or some third information has done. So this will not be covered under the misrepresentation, that later on you cannot set aside the contract that I have purchased the shares on the advice of my friend. That's not permissible in this. Misrepresentation must have been addressed to the other party when two parties are entering into the contract. So they must have, the access to the information. So if anyone, the information is given to someone else, A is saying to C that probably Mr. A will join as a director of the company, but you keep this information confidential, and then the C is telling it to B. So in both ways, it will not affect the consent of the C. So if B has entered into the contract on the words of the C, or A has shared it with C, it will not give the right to B to set aside the contract. So there is going to be a valid contract. It will not be covered under the concept misrepresentation. Then it must have affected your mind. It must have given you the possibility on the basis of which you have entered into the contract. Then let's move further, that if we talk about the effects of misrepresentation, so effect of misrepresentation is the contract is voidable at the option of the party whose consent has been so affected. So in this case, there is possibility that you can set aside the contract or you can insist upon the performance, stating that the other person who have made the misrepresentation, that statement would have been actually true or existed. For example, there is that you have purchased a mobile phone, and this particular phone requires certain kind of feature or some software, right? So you have specifically asked for that. So the particular mobile phone was not carrying that feature. So before taking it, or you ensure that it is to be replaced by the exact product which has been made by the other party. So in this particular situation, when you insist upon performance, you insist upon performance on the basis of that if the misrepresentation made would have been true, so which particular thing would have been entered into. So on that basis, you can enter into the contract. Right? Is it clear up till now? Yes, can we move further?
Yes, ma'am.
Yes, ma'am.
Okay. Okay, now we say
Yes,
that
ma'am.
what are the remedies or options available with the party in case of misrepresentation. So the very first right is right of recession. That is, you can set aside the contract and you can ask for the suit for recession as well as doctrine of restitution. So in this particular case, once you elect the contract to be set aside, then the contract will not be performed. The law gives us the right to set it aside on the basis that the consent of the party is not free, and here the consent has been affected by misrepresentation. But where the misrepresentation, could be seen, or the person as an ordinary prudence or normal intelligence, no technical skills are required, can make it out the facts and figures of the contract, then the person cannot set aside the contract. So, for example, we say that it is written that the memory of the phone is 64 GB, right? And it is written there, it is mentioned there, it is given in the specification clearly. Then, in that case, you cannot set it aside on the basis of that I had demanded of for 128 GB space. So, if a man of ordinary prudence, or suppose there is a person who is illiterate, cannot read and write, and he has totally relied on seller judgment and skill, seller is dealing in the particular product. So in that case, it was the duty of the person selling the product that it has this particular capacity. So if the person, illiterate person, has specifically asked for 128 GB and he is not able to read and write, then in that case, there is going to be, the product will be changed. For the person is bound to perform the contract, or except the person can set aside the contract. But where the person can, by a man of ordinary prudence, ordinary diligence, can find it out, the facts and figures in the contract, then the contract cannot be set aside. So, suit of recession will be available in case of misrepresentation, where the person has relied on the other party and the misrepresentation have affected the consent of the party. Then मिसरिप्रेजेंटेशन अगर कंसेंट को आपकी कॉज ही नहीं कर रहा है, इनडायरेक्ट है, बाय थर्ड पार्टी है, तब भी आप उसको सेट असाइड नहीं कर सकते. You were aware of misrepresentation, you have seen that the other person is giving the wrong product, still you have accepted that, then also you cannot set aside the contract. And if third party have acquired the rights, or the parties could not bring back to the original position, then in that particular case, this right of recession cannot be used, or the contract cannot be set aside. Let me share a personal example. Last year, I have purchased, in last lockdown, I have purchased the new laptop. And this particular laptop, when we purchased, so it was, it looked fine, and there was some scratch on the, top of the particular laptop, and it was not visible from a particular angle, because where the it has been displayed or shown, some reflection of light was there, that somehow it got missed. So we have got the Microsoft downloaded or Office downloaded, their account has been created. After a day, when we saw, when we got it at home and we have checked that there is some scratch on it, so we went back to replace the particular product. So it was said that if we would have not installed the office, or if you would have not registered this particular system, so they would have changed the hardware. So again, when the parties could not be brought back to their original position. Similarly, later on, there was some difficulty with the camera for many months. Its inbuilt camera or inbuilt feature could not be worked upon. So in that scenario, they have offered the repair, or they have offered the replacement of the camera, but again it did not work. So they have offered the external camera for the same. So once we said yes, because it's not getting right, so they have replaced the, or they have given the external camera with the particular laptop free of cost. So in this case, if there would have been certain kind of misrepresentation that this particular camera, because I needed this laptop for taking my classes, so camera and other things were essential part of it. So in that case, if there would have been misrepresentation that there is a camera, it is working, etc., and it is not working, and then they replace it, so all these things goes on. And when we'll discuss in detail about the sale of goods act, so we'll discuss about the product description and all these parameters in much detail, right? So I hope it is clear up till now कि right of recession कहाँ पे use हो सकता है और कहाँ पे नहीं use हो सकता.
Yes, ma'am.
Okay. Then there is another option is available, right to insist upon performance. So we have contract is voidable. Either we can set it aside or we can perform. But in case of coercion and undue influence में हमें as it is perform करना पड़ता है. लेकिन जहां पर misrepresentation और fraud आ जाता है, तो वहां पर हम we can insist upon the performance on the basis of that, as if the fraud or misrepresentation or the statement made would have been true. So in that case, the person, other party, to put him in a position in which he would have been if there would have been no misrepresentation. तो अगर मिसरिप्रेजेंटेशन नहीं की होती तो पार्टी की क्या पोजीशन होती, उसके बेसिस पे हम परफॉर्मेंस के लिए इंसिस्ट कर सकते हैं. The third option or third remedy in case of misrepresentation is right to claim damages. But in case of misrepresentation, damages cannot be claimed in all the circumstances equally. It is available only in case of wrongful dishonor of your check. And secondly, it is available in case of wrong statement in the prospectus. And if there is any kind of confidential relationship exists, so there if the person is making any misrepresentation, there you can claim for damages. Otherwise, normally it cannot be claimed as damages. But whereas we talk about the fraud, to fraud may damages can always be claimed, but in that case the person must have suffered the loss. So this is about we can say the fraud and the misrepresentation. Any query up till now?
No, ma'am.
No, ma'am.
Okay, so let me just show you the remedies for fraud, and then we'll move further for mistake. Okay, so here when we discuss about the remedies available in case of fraud, so we have discussed about right to resign the contract, right to set aside the contract. But again, where the person had the means to discover truth by ordinary diligence, we cannot set aside the contract. And also where we have affirmed the contract, we have here said yes, accepted the contract, or where the reasonable time is over, or the third party interest have been and intervened, or where we have affirmed the contract, then in that particular affirm the contract means that the performance of the contract. So in these cases we cannot set aside the contract. So in case we can insist upon the performance and we can claim the damages. So if the loss is suffered, damages can be claimed and fraud is tort, hence compensation is payable under the law of torts only. But the compensation or damages can be claimed as a matter of right in case of fraud. So now the next assignment or next task you have to do is the difference between misrepresentation and fraud. So I hope you'll be able to do that. Yes.
Yes, ma'am.
Okay. Now let's move to the another last element which makes the consent unfree, that is called as mistake. तो mistake के अंदर हमारी दो situations हो जाती हैं. एक आपका हो जाता है there is no consensus. So we have already discussed in first chapter that if there is no consensus at idem, there is no contract. So it means that there is bilateral mistake by the parties with respect to any of the element. I would like to show you one document, but just we have to remember कि यहाँ पर अगर bilateral mistake है तो आपका जो agreement है वो आपका void हो जाएगा, right? But if there is a unilateral mistake, only one party is at mistake, then in that particular case it cannot be set aside. It can't set aside the contract. So in that case, in certain situation, it is valid. In certain situation, the circumstances will decide about the validity of the contract. So let me share with you a document. Actually, I got a little late for today's class because I was arranging this document for you. So is it clear? Is it visible to you?
Yes, ma'am.
Okay.
Yes, ma'am.
Right. So now, if we see, my dear friends, if we talk about the mistake, so mistake can be divided into mistake of fact and mistake of law, right? So broadly, we say that mistake of fact is the sort of bilateral and unilateral mistake about the subject matter of the contract, and mistake of law is the mistake of law of land and mistake of foreign law. So if we talk about the mistake of law of land, so there is no excuse. So if you commit mistake related to law of land, it is going to give rise to a valid contract. You do not have a choice that you were not aware of the law. You have jumped the red light and you are talking that I was not aware of that the jumping of red light is an offense. It will not spare you or will not make you excusable that you do not have the knowledge or you have made mistake on this account. But definitely, if we talk about the foreign law, so we are not supposed to have all the details or all information in respect to the foreign law. So there, if you made certain kind of mistake with respect to foreign law, depending upon the circumstances, this is excusable. But if we talk about the IPC or any kind of criminal activity, so you cannot say that because it is happening in foreign, so you are excusable. So that is not there. But with respect to certain specifically terms and conditions, certain rules and regulations, so if you are dealing with, that's why we say that whenever we are entering into a contract with any other country, so we take the expert advice, we take the legal consultancies, we take into account all the details, or we have the professionals to guide us for the same. So we do not enter into the contract as it is. But in certain cases, if certain mistakes are being made or certain you are not aware of certain rules of the foreign law, still there is a possibility that it is excusable. But if we talk about law of land where you are residing and if you are making any mistake, you cannot excuse it on the ground of the mistake. So it will remain valid in that circumstance. But when we talk about the mistake of fact, so mistake of fact means कि जिस particular subject matter से related हम कॉन्ट्रैक्ट कर रहे हैं, तो उस सब्जेक्ट मैटर से रिलेटेड अगर आप कोई मिस्टेक करते हैं तो उस मिस्टेक को आपका जो अग्रीमेंट है वो वैलिडेट नहीं करेगा, कॉन्ट्रैक्ट नहीं बनेगा, लीगल ऑब्लिगेशन नहीं आएगी. So it would depend upon that whether we are making both the parties are at mistake or both the parties are not at mistake. So if both the parties are at mistake, it means there is no consensus. No consensus means that parties have not agreed about the same terms and conditions, and also at the time of formation of contract. At the time of formation of contract, right? So in this particular case, if there is a bilateral mistake, the particular agreement is going to be void, right? So in that case, if we talk about the bilateral mistake, so you see that bilateral mistake can be with respect to the subject matter of the contract or can be with respect to the possibility of performance. Possibility of performance के अंदर आपकी physical impossibility हो सकती है, legal impossibility हो सकती है. तो उस केस के अंदर आपका अग्रीमेंट वॉइड हो जाएगा. यू मस्ट हैव रिमेंबर, हमने डिस्कस किया था वॉइड कॉन्ट्रैक्ट के ऊपर कि अगर आपकी सब्सिक्वेंट चेंज ऑफ सर्कमस्टांसेस हो जाता है और उसमें सब्सिक्वेंट इम्पॉसिबिलिटी हो जाती है, then the particular contract ceases to be enforceable by law, and this subsequent impossibility में हमने legal impossibility और physical impossibility को डिटेल में डिस्कस किया था. वही चीज है, void contract कब होगा? जब हमने एंटर किया तो वो enforceable by law था, बट लेटर ऑन चेंज ऑफ सर्कमस्टांसेस के कारण, सब्सिक्वेंट इम्पॉसिबिलिटी के कारण, डिस्ट्रक्शन ऑफ सब्जेक्ट मैटर के कारण या लीगल रूल्स के चेंज के कारण it ceases to be enforceable by law. But here when we talk about the void agreement, तो void agreement means कि जिस टाइम हम कॉन्ट्रैक्ट कर रहे हैं उसी टाइम वो पर्टिकुलर सब्जेक्ट मैटर एग्जिस्ट नहीं करता. Either that subject matter does not exist physically or there are certain legal restriction with respect to that subject matter. तो उस केस के अंदर वो अग्रीमेंट void हो जाएगा. Void agreement means not enforceable by law at all. So it will not give rise to any kind of obligation, any kind of legal rights, legal duties, etc. Right? And physical impossibility means कि वो particular product या particular item और the particular subject matter जिसके लिए आप contract कर रहे हैं वो at the time of formation of contract exist ही नहीं करता. So once the subject matter does not exist, it cannot be performed. So in case of possibility of performance, if both the parties are making mistake, be it physical impossibility or legal impossibility, it will give rise to a void agreement. And if we are making mistake with respect to the subject matter, so then this particular case subject matter existence से related हो सकता है, identity of parties से related हो सकता है, price से related हो सकता है, title of title means the ownership of the particular item हो सकता है, quality से related हो सकता है, quantity से related हो सकता है. So if both the parties are making mistake, either there can be a common mistake or there can be a different mistake. One person is making mistake with respect to the existence, other person is making mistake related to the price. One person is making mistake related to the title, the other party is making mistake related to the quality. But both the parties are at mistake. It means that there is no consensus. We are not talking about the same subject matter. We are not talking about the same thing. तो जब हम उस सेम थिंग के बारे में बात ही नहीं कर रहे हैं, so how it will give rise to a legal, we can say, rights or legal obligation. So in that case, the particular agreement is going to be void agreement. It will not give rise to any of the legal rights and obligations, right? So this particular chart is clear to all of you? Yes?
Yes, ma'am.
Okay. So now let's move to the presentation. Okay, so when we talk about the mistake means a belief concerning something as a result of which there is a misunderstanding among the parties. So this particular mistake can be in terms of agreement indifference, error in consensus or consensus at either, right? Then we talk about type of mistake as to law in India, mistake as to foreign law. So the contract is not voidable as on the ground of the mistake by as to any law force in India. But mistake as a law not in force in India has same effect as a effect of mistake of fact, means that you were not aware of the fact of the situation. Or if there is mistake of law of country, the contract is binding, it will give rise to a valid contract, and because the ignorance of law is not an excuse. Then, when we talk about the mistake of fact, bilateral mistake means when both the parties are at a mistake about the facts of which are essential to the contract. If it is not essential to contract, it will not be regarded as mistake. And where both the parties are at mistake related to essential or subject matter of the contract, the agreement is void. Mistake can be some same mistake or can be mutual mistake, that one party is making mistake related to the one aspect of the subject matter, the other party is making mistake related to the other part of the subject matter. So bilateral mistake can be of subject matter about the possibility of the performance. So in that case, the non-existence of the subject matter will lead to void agreement, be it the physical impossibility to perform or legal impossibility to perform. So in this particular case, if we talk about the subject matter, so again about the identity, quality, price, or we can say the other matter of the subject matter, it can be there. And bilateral mistake about possibility of performance, we have already discussed physical impossibility and legal impossibility. And unilateral mistake, unilateral mistake is a part that where one party is at mistake, but contract is not voidable merely because it was caused by one of the party of it are being at mistake as a matter of fact. So type of mistakes, we talk about the identity of parties. So there is a case law of Lindsay wherein it is said that the parties A has placed an order to B, right? And B has already sold the shop to C. So now C is, C has delivered the order to A. A is not bound to make payment to C. A doesn't have the legal obligation because A has entered into the contract with B. He has placed the order with B. He has demanded the goods from B. But these goods have been supplied by C because B has already sold the shop to C. So there is the mistake with respect to the identity of the parties. So in this particular case, A does not have any legal obligation towards C because someone else's have performed. So if you remember the doctrine of privity of contract, so doctrine of privity of contract says that only party to contract can sue each other, can compel each other, gives rise to legal rights and obligations as such, right? So similarly, with respect to the other aspect, there can be the difference of opinion or the person have talked about the different things. Now we talk about the effects of mistake, that wherever the person have made the mistake. So in this particular case, doctrine of restitution applies under section 65. Normally, if we talk about the coercion, undue influence, fraud, misrepresentation. It is doctrine of restitution is applied under section 64 are in voidable contracts. But in case of the void agreement, section 65 says that on the basis of no one is allowed to enrich himself at the expense of the other. So if any benefit or money, etc., is being received, so in that case, in case of mistake as well, the person is bound to restore or return the benefit money which is being received by the party to the other party. And bilateral mistake contracts are void. So in that case, doctrine of restitution may not apply in certain cases, but may be given by the court of law, ordered by the court. And unilateral mistakes contract are void except where they defeat the true consent of the parties. So that's it in this particular chapter. Now house is open for your queries, doubts, and discussions, and any other information or details you wish to discuss.